Hello, welcome to this KSA PDPL, Your Path to Compliance. My name is Bilal Ghafoor. This webinar was originally delivered on the 10th of September, but a few people have asked to have a recording. We didn't record it to allow people to pose questions, so I thought I would narrate this again. So what we're going to talk about is a very, very basic introduction to PDPL. What's the worst that can happen? Because whenever we're looking at compliance-driven things, that's what we kind of want to get a sense of. What is SDIA, which is the supervisory authority? What are they likely to do? What you need to do. So we'll talk about the NDMO phases, a roadmap, and then there'll be some concluding remarks. So the very, very basics of the PDPL is, as people know, it's going to become enforceable from the 14th of September, which is just a few days away from the point at which I'm recording this. It's been on the books for quite a while, and it's gone through quite a lot of changes, but it looks like there won't be another delay because we're now right on the threshold of the enforceability date. The law looks a lot like Dubai's law or the GDPR. So they're all driven by individual rights and principles. So if you're conversant with the GDPR, then none of this should be too much of a surprise to you. Now, the text of the PDPL standing just by itself is relatively incomplete. There's a lot of detail that is being published in regulations and guidance. The regulations and guidance are being published at a furious rate by SDIA. I mean, almost every other day, it seems, for the last few days. So it's incredibly important not to just read the PDPL, but to read the regulations and everything else that they pump out. So as mentioned, the regulator is SDIA, the Saudi Data and AI Authority. They will be the people who are in charge of regulating the PDPL and making sure that organizations comply. I'm going to talk about the transfer regulations because a lot of our clients are international in nature, and they obviously want to know about data movement in and out of the country. There had, of course, been a lot of concern about this because earlier drafts of the PDPL essentially practically banned these data transfers, which would have made life absolutely impossible. So if your data center for your Office 365 was sitting outside of KSA, which it very likely would have done a few years ago, then you couldn't use it if you were putting any personal data into it. That would make life absolutely impossible. But now the new ones are a lot more relaxed. The PDPL only set out one purpose unless you were within government. It was performance of an obligation to which the data subject is a party. That covered some things, but there were a lot of organizations that still would not be able to transfer data in and out. But the new regulations are much, much more helpful. So they include performing necessary operations for central processing to enable the controller to conduct its activities and providing a service or benefit to the data subject. So that's kind of where most of our clients are going to end up, providing a service or benefit to the data subject. You no longer need a direct contract with the data subject. So long as you can document that you're providing them with a service or that it's benefiting them, you should be good to use that as a basis for your data transfer. And aside from a bit of documentation, that shouldn't make life too difficult. Of course, we now want to know what SDIA might do. Now, the thing that everyone is banding around are these 5 million real fines, which absolutely do exist. In fact, they can get doubled. The real question is that a theoretical fine or not? We're going to have a think about that. The other one is people have been banding around this idea that people can go to prison, and you absolutely can. What you can go to prison for is for the deliberate release of sensitive personal data with the objective of harming someone. So that's kind of quite obscure. It's not terribly clear right now whether if you were doing this as part of your organization's purpose and it was a legitimate purpose, whether that would make you susceptible to prison. But either way, we definitely want to make sure that we don't disclose sensitive data inappropriately. One other peculiarity which you will not see, I mean, you do see it in the GDPR, it's never really used, is that a supervisory authority can stop you processing your data. Now, if a supervisory authority comes and knocks on your door and says, hey, stop processing data, essentially your organization is dead. You can't really do anything unless you are in, for example, manufacturing, but even then you might not be able to payroll people. SDIA has a power that, without deeming you guilty, says not as a punishment, but actually at the point at which they want to undertake an investigation, they can suspend your data use. Now, the real question is will SDIA do this at any point? All we can do at this point is, because even SDIA itself is a relatively new entity, is we can look at the lessons from the other Gulf countries. And now if we look around at, for example, Dubai, and various other countries, because certainly the Kingdom is not first to the party at all with the data protection law, we look around and we see that actually there hasn't been very much fining activity. It's not terribly clear why. Because Europe has been going for a little bit longer, it might be wise to look at Europe, although of course SDIA is not at all bound by what Europe is doing. It's a completely separate entity, entirely independent. But it's certainly true that in the first year of the GDPR coming in, and we might remember 2018, people were predicting an apocalypse. It is certainly true that they were, the supervisory authorities, I think, issued around 22 fines in the first year. So 27 countries issued 22 fines. It wasn't a lot of activity going on. It's possible that they were trying to be business friendly. Now, later on, so we look now a few years later, and fines have totaled the tens of millions of euros. Now, is that the position that SDIA is going to take? It's very, very, very difficult to figure this out. But certainly it should be of no surprise to anyone that in the first year, most of these organizations are not fining. That does not mean we do nothing. It means that we might have a little bit more breathing space than SDIA has strictly given us to actually make sure that we comply, so that if things change further down the road, we are proofed against fines. If we look at lessons from other laws, now one of the main and most regulated things in Saudi Arabia, which again won't apply to most clients, but it's a place where we can learn some lessons, is SAMA, which is a regulator for the finance industry. So they look at banks and finance brokers, insurance, that kind of thing. They certainly had a very, very large appetite to fine people right from the start. And it could be said that maybe they were doing this to make examples of people. Will SAMA do the same thing? Well, Saudi Arabia is a relatively small country in terms of population size. The civil service is relatively small, and is there going to be a merry-go-round of staff going from one organization to another? Can't deny that there might be some kind of influence. Either way, can we say for sure whether fines will happen or not? No. Absolutely, we can't. What we can do is we can say, let's make sure that if such a thing happens, that we're not in the firing line. For clients that are based in Saudi Arabia, you will need to comply with the PDPL, and the NDMO has issued guidance in phases. So the NDMO is the National Data Management Office. The National Data Management Office, along with the PDPL coming out, there has been a huge set of directives coming out around data management. And these are, in fact, a slightly bigger piece of work than the PDPL. These apply generally to central government, to very highly regulated authorities and organizations, such as finance or financial sector, some health sector, etc. Most commercial organizations are not really going to have to comply with these, but they set out their standards in 2021. Within this, Domain 9.14 explains the data protection domain in 5 phases. Confusingly, NDMO got in touch with various organizations to ask them to do phase 1. Some organizations are on phase 2, and some organizations have done absolutely nothing so far, so as far as we can see. This is literally copied from the NDMO guidelines, and I'm going to try and break this down a little bit, but I don't think we need to pay that much attention to this because the way in which these phases work don't actually make a lot of sense. So phase one, which actually does make sense, is make a plan, have an initial assessment, and make a data protection plan. Perfect. Sounds entirely reasonable, and phase one is good. Phase two, strategy, it says training and awareness, and this suggests that we should deliver data protection training. Phase 3 and 4 and 5, I'm not going to go into in too much detail, but they then start talking about all the other things that we would expect as part of a data protection regime. Notice that register is actually the last phase, and a register is a is an information asset register required for the PDPL, where you note down all of the personal data you have and information about it. Now, this is all very, very, very strange. So phase 5 is a personal data protection register. And for us, it seems actually impossible to start a privacy program without understanding where your register is at. And I'll talk about that in a minute or so. There are other peculiarities about the order in which this is being rolled out. So, for example, you train your staff before you know how to handle breaches. It's not entirely clear what you would be training them on, except that you probably need a suite of policies and procedures to train them on what is data protection and then how to get the best out of the guidance and the training that you're making available so that they can actually act. So that seems like a very, very strange order in which do things. For us, the register of data, which is the records of processing activities, is the heart of everything. This is a register within which you will note down what kind of personal data you have, where you store it, how it's accessed, who it's shared with, what the lawful basis is, how long you hang on to it for, lots and lots of things. Now, very clearly, without that kind of register, you can't do very much. You certainly can't do security, because how can you do security without knowing what personal data you have, where it's stored, who can access it, where you got it from, how sensitive it is, and things like that. So it doesn't really make sense to be able to do this. One example I like to give is the idea of, let's imagine you go up to your IT manager and you say to them, I want to take control and understand our IT assets. Can you give me a list of all of our laptops, mobile phones, mobile modems, all the software installed on it, and who's got, or where these things have been deployed to, how old they are, etc. If your IT manager turned to you and said, sorry, I can't give you that list, you would think, I don't think this person's going to last very long, because without such a register, you cannot fundamentally keep control over your assets. And a data register or a record of processing activities is exactly the same thing. You can't do security without it. Unless you've written down all of your data processing, it becomes almost impossible to work out your lawful bases. You can't work out how to add privacy by design and default. You don't know where the data is flowing to, so which third parties are getting access to it, and so what contracts you might need, what data processors you have that are processing data on your behalf, and you can't really figure out what cross-border transfers you're doing. So for us, the data register is absolutely the heart of all of this activity. And that kind of brings us on to our 9-step plan. So at the start, we would do an audit and build a plan. We'd then build your records of processing activities or your data register. After that, we'd put together policies and expert guidance, data protection officer and training. Now, some organizations want us to train up your own data protection officer, and we're really happy to do that and then support them in the early months or years before they become a fully fledged and experienced person that can do your data protection for you. Otherwise, we're very happy to deliver training to your staff. We'll look at security, particularly in terms of breach management and crisis management. We'll look at your lawful bases. Individual rights, people will suddenly start to make access requests, copies of their own data, and there needs to be a very, very clear process and training for people to handle those. Privacy by design in default is a very, very strong idea, which is contained implicitly in the GDPR and is explicitly within the PDPL. These are principles whereby privacy has to be baked into your products and has to be the default of all of your products. So we will help with that. We'll assess all of your cross-border transfers, your contracts and data processes. So by way of conclusions, I guess, I think all I really have to say is that it's not a scary thing. If you have done some work around GDPR or other data protection regimes, you're probably in a pretty good place. The things to do are to work out what your data register is and work out your risks, reduce those, use the PDPL text and the guidance, and let us know if we can be of any assistance to you whatsoever. I hope this was useful. Thanks very much.